Welcome to those of you that have joined us. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined us. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join us before we start. Whilst we are waiting for everybody to join us, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screens, and our speakers will try to come to the questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to remind you that we now have a separate section on the Five Stone Buildings website for webinars, where you'll be able to find a copy of this recording and the slides used and any previous webinars that have taken place. I will now hand over to Sarah and Arabella.
Thank you very much, Jo, and good afternoon, everyone. I'm very pleased to see so many of you joining us. I can see the numbers creeping up as I begin to speak. So we are going to talk briefly this afternoon about some fairly discrete issues that can be overlooked or misunderstood in the administration and distribution of estates. This is by no means meant to be a comprehensive analysis of everything that can go wrong in the administration of an estate. And in particular, we're not going to touch on things like the incidence of inheritance tax or how that gets borne or apportioned, which frankly is worthy of a webinar in itself. But there is a common thread in the topics which we're planning to cover this afternoon, which is really how wrong turns can be taken in the distribution of an estate because of the failure, or perhaps the non-failure, of gifts in a will, and also the incidence of expenses and how they should be borne. This talk's really been inspired by some problems that we've encountered in practice. It's not influenced really by any recent decision. But what I realized when I prepared this talk is that the topics I've chosen in particular really turn on some very fine distinctions, which are neither intuitive nor instinctive, and perhaps not readily understandable. So for a busy practitioner, we hope this talk highlights some of the unknown unknowns that are out there, or perhaps for some of you to remind you of familiar friends whom you may not have seen for some years. So without further ado, I'll turn to the first topic, which I'm going to speak about, which is gifts to charities which have ceased to exist? Or perhaps the real question is, have they ceased to exist? Because the headline point here really is that unlike an individual or a normal company, charities which you think may have ceased to exist can, zombie-like, have a life after the grave. And I'm going to explore how that happens and what you do about it. Just to set the context, I'm not talking here about a misdescribed charity, which is really a different question, and it's a question of identifying what the charity described in the will was intended to be. Rather, the situation I have in mind is where, for example, you've got a gift to a charity which you know existed and was correctly described in the will, but has somehow metamorphosed or disappeared altogether. So, for example, a gift to the Jemima Puddle Duck Association, which promotes the welfare of poultry in Devon, but which, since the will was drafted, has ceased to be operative. Now, there are various stages in the analysis which you have to go through to work out whether or not the gift to the Jemima Puddle Duck Association lapses, or whether it somehow survives for the benefit of another charity. The first question you've got to ask yourself is whether there's been a relevant charity merger which has been registered. And that's a provision of the Charities Act, section 311 of the Charities Act, which really allows the transfer of assets or a charity's operations from one charity to another. And by statute, the successor charity is deemed to step into the shoes of the charity named in the will. And that's quite straightforward. What you have to do is check the Charity Commission website, you put in the name of the old charity, and that should tell you whether or not there's been a relevant charity merger. Sadly, a lot of associations, and let's assume the Jemima Puddle Duck Association falls into this category, don't, for whatever reason, get round to registering a relevant charity merger. So then the next question, assuming there's no relevant charity merger, is, does your will help you at all? And in particular, a well-drafted will might include a provision which allows the executors to pay to another charity carrying out a similar object, or a charity which appears to be a successor to the original charity. And in particular, if your will incorporates the step standard provisions, if you look at those at paragraph 4.16.2, they say, if any charity ceases to exist, changes its name, or enters into insolvent liquidation before the time that a gift to the charity takes effect in possession, the gift shall instead be paid to such charity as the trustees decide, having regard to the objects that were intended to benefit. So, phew, you wipe your brow with relief, because you don't need to worry about having to go to court or anything more complicated than an exercise of the executor's discretion to identify a successor charity. But again, sadly, not all wills are well drafted or contain these sorts of provisions. So here you get into murky waters. The next question is whether the gift to the old or non-existent charity is a gift to that body, which is dependent on that body continuing to exist in that form, or whether it's a gift to it on trust for its charitable purposes. If it's the latter, on trust for its charitable purposes, then if those purposes are still being carried out, a scheme, what's called an administrative scheme, can be directed, whereby the gifted property is redirected to whichever charity is now carrying on the purposes. And that's an administrative scheme rather than what I'll come on to describe on the fifth bullet point, or sixth bullet point, a CPRE scheme. Now, there is here a very fine distinction between the treatment of incorporated charities, so charitable companies, and unincorporated charities, like, let's assume, the Jemima Puddle Duck Association. That gift to an unincorporated association is normally, unless there's some indication to the contrary, treated as a gift to the body on trust for its purposes. But the position's the reverse if you've got a gift to a charitable company. In that situation, the starting point is that, absent some indication to the contrary, the gift to the company is a gift to it as a body, not on trust. And this is described in a couple of cases from the 1970s. Re Fingers Will Trusts is actually the second of the two. And in Re Fingers, Mr. Justice Goff said that if he was approaching it res integra, which was a time at which you could use Latin in judgments, but really afresh, then there would be much to be said for the view that it didn't matter what the status of the donee was. It shouldn't matter whether it's a company or an unincorporated association, the rules should be the same. But he was following the decision of Mr. Justice Buckley and Re Vernon, where that distinction was drawn, largely probably because an unincorporated association has no legal personality. And so the idea of giving to it doesn't really make sense. And Fingers is a good example of a gift where there were both unincorporated associations and incorporated bodies. So the testatrix, Georgina Finger, had left her estate to be divided between 11 charities, 2 of which had failed by the time of her death. One of those that had ceased to exist was the National Radium Commission, and that had been an unincorporated body, whereas the National Council for Maternity and Welfare had been incorporated. And what the judge found was that the gift to the National Radium Commission was a gift on trust for its purposes and directed a scheme. The National Council for Maternity and Welfare wasn't a gift on trust for its purposes. But, as we'll come on to see, the gift to it was saved by an application of more general CPRE rules. All right. So to get to CPRE, to get to the question where it's not a gift on trust for purposes, it nonetheless gets applied for charitable purposes. The question is whether the will discloses that the testator had a general or a paramount charitable intention. And if he or she did, then the court's able to direct a CPRE scheme, which means it's applied for a charity which carries on a similar charitable object to the one that the gift had contemplated. When does a general charitable intent exist? Well, you find it if you discern that the paramount object of the testator was to benefit not a particular institution, but to effect a particular form of charity, independently of any special institution or mode. So really, the overall objective was to benefit charity, not that particular body. In the past, there's been a certain reluctance to find that there is that general paramount intent. And so there's an old case from 1935 called Re Harwood, where the judge said that where a testator selected a particular object, a particular charity, and identifies it with some care, then it's difficult to find a general charitable intent. I think the more modern approach, and I say more modern, but looking at cases from the 1970s, is that there is a tendency to be a bit more relaxed about finding a general charitable intent. And so, for example, in Re Fingers, the case I mentioned earlier, the judge found there was that intention from the fact that the testatrix had divided her estate between 11 different charities. And also there was a factor in the gift to the National Maternity Council, which was that it was a coordinating body. It wasn't itself carrying out charitable work, but it was giving to other charities to effect its purposes. However, the headline point really to take away from this is the sort of process involved, because the important practical thing to bear in mind is that if you're not in the territory of a relevant charity merger or having a provision in the will which allows you to distribute to a successor charity, then unless you're able to get the consent of everybody who might be affected to administering the estate in a particular way, you are likely to have to go to court to get an order to protect you or to tell you to whom the fund should be distributed. And this problem can particularly arise where you've got a gift to a charity as part of your residuary gift, and that lapses, and your question is, does this go on an intestacy, or does it somehow survive for the benefit of charity more generally? And the Charity Commission isn't going to be able to help you with this, because what the Charity Commission can't do, although it can direct schemes, what it can't do is decide whether or not the interested people are the intestacy beneficiaries or charity more generally. So I think that brings me to the end of my first pitfall, and I shall hand over to Arabella to take you through the second.
Thanks. So we're going from failure or non-failure of charitable gifts to the failure of testamentary gifts in general. I'm going to just be setting out the basics of failure of testamentary gifts, and I suspect it's all going to be quite familiar, but it can be useful to go over the basics because occasionally the ins and the outs of it get overlooked with everything else that's going on during administration, and it can cause unnecessary problems if it's not been ironed out from the start. It's also important to have a solid grasp of all of the possible destinations of a particular part of an estate, especially if there's a construction issue with the will, because as executor, you would have to work out which people are potentially affected by each alternative construction of the will. Gifts by will can fail for numerous reasons, and we don't have time to go through an exhaustive list, but the common ones are a beneficiary predeceasing the testator, causing the gift to lapse, a gift failing for uncertainty, the beneficiary or their spouse having been an attesting witness to the will, the dissolution or annulment of the deceased marriage to the beneficiary, and perhaps less common, but it does happen, a beneficiary disclaiming the gift. Failure of one or several gifts does not, of course, mean that the will as a whole is invalid, which is sometimes a worry of beneficiaries, but the effect of failure will depend on the drafting of the clause containing the gift, and also on whether the gift was a specific gift or a gift of all or part of the residuary estate. Where there's a failure of a specific gift, in general, the subject matter of the specific gift which fails will pass under the residuary gift contained in the will. So it will be brought under the umbrella of the residuary estate. That said, there are some situations in which the wording will make it clear that no part of the gift will fall into the residuary estate, even if, for example, one of the beneficiaries has predeceased the testator. So, for instance, a gift of my jewellery to such of my sisters as survive me, and if more than one in equal shares, is obviously going to be fine if one of the sisters predeceases, as long as at least one sister survives the testator. If one or more sisters do survive, there's no failure, so it's not going to be swept up by the residuary estate. It's certainly less common, but there could also be a situation in which the testator could show an intention with some kind of wording in the will to exclude the subject matter of the gift from the residuary estate in any event, even if the specific gift fails. In that case, if the drafting was successful, the subject matter of the specific gift that fails wouldn't actually fall into the residuary estate, it would pass on intestacy. Turning now to the failure of a residuary gift. If the residuary gift in a will fails completely, the residuary estate will pass on intestacy. If a gift of a share of the residuary estate fails and the will doesn't cater for what happens next, this will result in a partial intestacy. It's straightforward once you're familiar with the rules, but there's sometimes an expectation from beneficiaries that a failed share will simply go to the other residuary beneficiaries. You can see that if you have someone who's a residuary beneficiary with a share of the residuary estate, and they know that one of the other residuary beneficiaries has predeceased the testator, they might well expect that their own share will automatically be larger as a result. But in reality, it won't be unless the will caters for that. Typically, though, a professionally drafted will does cater for this so that the testator doesn't end up partially intestate. Partial intestacies in these circumstances are often avoided through the use of accruers and substitutions. An accruer is a clause which provides that the failed gift will accrue or be added to another gift which has independent effect under the terms of the will. So the failed part can be tacked on to a successful part. A common example would be where the residuary estate is left to the testator's 3 children, but if any of those children predecease him, that child's share will be added to the shares of the children who do survive. A substitutionary gift is where a gift is made to pass to another beneficiary who's only brought into the picture as a substitute for the original one. They might not otherwise benefit under the will at all. So again, commonly the drafting might specify that if the intended beneficiary has predeceased the testator, that beneficiary's children can take in substitution. And then you might have a clause that mixes together both accruers and substitutions. A testator might leave his residuary estate to A, B, and C, and provide that if any of those beneficiaries predecease him, there will be a substitutionary gift to that beneficiary's children. But if that substitutionary gift fails, perhaps because they didn't have children, the share will accrue onto the share of the surviving beneficiaries. So really there's a mix of both so that all situations can be catered to. I'm sure that you'll all have seen lots of examples of standard accruers and substitutionary gifts in practice. So here is a historic example of a substitutionary gift that you might not have seen. This one's over 400 years old. Good luck with reading all of that Old English. It's from Shakespeare's will. I don't know what you think, Sarah. I don't think we can recommend this drafting as a precedent, but I understand that Shakespeare was in difficulties and he wanted something a bit bespoke and complicated because his daughter Judith had just got married and he didn't like her husband, didn't want him to benefit. So I think that's where that comes from.
Well, there's a pleasing number of typos in it anyway.
I'm not sure there are typos. Not for him, at least. Yeah, over to you.
Great. And that links very well, Arabella, to the next slide, which is the next topic, I think. Yes, is Section 33 of the Wills Act, because that does bring into play some of the principles that Arabella's just been talking about of accruers and substitution clauses and how they relate with this particular piece of statutory drafting. So I'm sure you're familiar with Section 33 of the Wills Act, but just to remind you, it applies where you have a disposition in a will in favour of a child or remoter descendant, so includes grandchildren and great-grandchildren. And the intended beneficiary dies before the testator but leaves issue. And then, unless there's a contrary intention appearing by the will, the issue of the intended beneficiary step into the shoes of their parent. And I should say that that's where you've got a gift to a child. There's a similar provision in Section 33, subsection 2, in relation to class gifts. So to my children or to my grandchildren, as opposed to a gift to my son. Now, the crucial question really here is what amounts to a contrary intention? And in particular, what about the sort of standard clauses to A, B, and C as are living at my death, and if more than one equally, the sort of accruer clause, almost that Arabella's been talking about, or to such of A, B, and C as survive me, and if more than one in equal shares, or to such of my children as survive me. Does the reference to surviving or living in equal shares amount to a contrary intention? Well, there've been a raft of cases on this. If we go to the next slide, you can see what they are. Oh, I think we seem to have skipped ahead. Go back one. Oh,
sorry.
That's all right. I'm going to get my pictures in, so we'll.
There we are.
There we are. Brilliant. Okay, there have been a raft of cases. They're all the pictures, well, apart from a slight whimsy on my part, are because the names of them all have this sort of natural, some botanical or connection to nature, which I've attempted to illustrate. Not very scientifically correctly, because that's definitely not a ling on the top right hand side. The first of the cases, though, is Ling and Ling, which is now about 20 years old. And it was a class gift to such of my children living at my death who attained 21, and if more than one, as tenants in common in equal shares. The judge there held that there was no contrary intention, that Section 33 did apply to the share of a child who had predeceased the testator but left issue, so that they skipped in, and instead of therefore the two surviving children scooping the pool, the estate was divisible in thirds between the two surviving children and then the issue of the child who had predeceased. But things hit a slight diversion when we got to the next decision of Rainbird and Smith, where the relevant clause was to such of my daughters, A, B, and C, as shall survive me, and if more than one in equal shares. Now, the sort of thing about Rainbird and Smith is, well, first of all, the judge came to a different conclusion from that in Ling, at least on the face of it, and said, yes, there was a contrary intention. Rainbird and Smith's quite an odd decision, though, because it was an uncontested application actually for rectification in the first place, because there was strong contrary evidence that the testatrix didn't intend her grandchildren to step into the shoes of any of her daughters. But the judge said, well, I can't rectify until I know what the will means. And I'm satisfied that the will means that Section 33 is excluded. And he rationalised the distinction between that case and the earlier decision of Ling and Ling by saying there's a difference between the word survive me, which implies that it's a condition that any gift passing be only to the survivor, and living. I'm not articulating that distinction very well, because it is quite a tough one to swallow, and it's all credit to our colleague in Chambers, I think Charlotte Edge, who persuaded the deputy judge to accept this rather fine distinction. But there it stood for some years until causing some consternation in the minds of anybody who had to advise on the application of Section 33, until the law was sorted out by the decision in Hives and Mackin. And there we had a gift to such of my sons A, B, and C who shall be living at the date of my death, and if more than one in equal shares, absolutely. There was also, it was B who predeceased in this case, and there was also a legacy to B. And note, I suppose, that to the extent that one can justify a difference between Ling and Rainbird on the basis of the difference between the word living and survive, Hives did come on the Ling side of the line. But the judge was not very persuaded that that was a relevant or sensible distinction. And he pointed out that what we have here in the words that I've quoted, is a standard form of bequest. It's generally understood to have a particular purpose and effect in a gift of residue. The first is as words of severance, so each beneficiary takes beneficially rather than jointly with the others, and secondly, to avoid a partial intestacy. But what it doesn't say anything about is whether or not there's a contrary intention to the exclusion, so that section 33 shouldn't positively be excluded. If it were necessary actually to contain a particular substitution provision, that would almost have the effect of reversing the presumption under section 33, which presumes that it will pass to the issue of a deceased child unless the will makes it clear otherwise. So section 33 is just one to remember, where you have a gift to a child and that child or issue, and that child or issue has predeceased. And in most cases, unless it's been expressly excluded, and many wills do, but unless it's been expressly excluded, the starting point is that it's going to apply. Arabella, over to you.
Did you know that there was a fish called a ling before this talk?
I did, because it's a great cryptic crossword friend, Arabella. It's the sort of thing that, it forms part of the answer to a clue. Anyway, so I was aware of it.
Very impressive. As Sarah said at the start, we thought we'd talk also about expenses and issues to do with expenses that can arise in the administration of an estate. And this particular scenario I'm going to discuss, we thought it might be useful to address because it's a common one. You are an executor or acting for an executor of a will, which provides for a beneficiary to receive a property that is subject to a mortgage. The estate is solvent, but where does liability for the mortgage fall? On the property itself or the residuary estate? The answer is in section 35 of the Administration of Estates Act 1925. The general rule is that liability for the mortgage will fall on the property that's been gifted and not the residuary estate, unless the will or a deed or another document signifies a contrary intention. Despite the statute being fairly clear on this, there is a recent case where this did form one of the questions before the court, and that's Re Ross, which is up on the slide. In Re Ross, the testatrix left her estate between her 3 children by means of a number of specific legacies. The value of the estate assets was higher than the value of its liabilities, so it was solvent, but the more valuable estate assets, which were some properties, had all been given as specific legacies. It's not quite clear in the judgment, but it seems that there was just no mention of any residuary estate in the will. And in any event, once you removed the specific gifts of the properties, there was only around £6,000 of cash left. There was an issue about just how high the liabilities against the estate were, as they included things like a claim by one of the beneficiaries for unpaid wages, but the figure ranged between 65k and 172k. So clearly the executor was going to have to resort to using the specific bequest to pay off the debts. So the general backdrop of the case was that the judge was asked to determine the proportions in which the abatement would take place and the question about the liabilities. But one of the smaller bones of contention was relevant to section 35 because clause 2 of the will bequeathed the property known as 13 Kensington Gardens to the testatrix's daughter, Diana. The gift of the property in the will was drafted as being free from any mortgage or legal charge to which the same may be subject at the date of my death. The property was on the market for about £115,000, but subject to a mortgage of £50,000 that was still outstanding. The other siblings were not happy with the prospect that their specific bequests might be used to discharge the mortgage on an asset that had been given to only their sister and that they'd get nothing from. They argued very strongly that the liability for the mortgage should be discharged in full out of the sale proceeds of the property that had been gifted to Diana. But the judge felt that the normal rule in section 35 had to be displaced because of the words "free from any mortgage" in the drafting. That was enough in the will to signify a contrary intention and to remove the liability away from the specific gift. So that's what happens when you have a mortgage or a charge. But we thought it might also be useful to talk about other expenses that commonly have to be paid during the administration of an estate. Things like the costs of the upkeep and maintenance of a property or any other specific legacy. Again, you might wonder whether that falls on the residuary estate or the specific legatee. I think I've gone one too far. There we go. It's case law rather than statute that provides the answer to that one. So there's a case called Re Pierce on the side from 1909 that is very 1909. The testator was Sir W.G. Pierce, Baronet, and he bequeathed to his wife all his furniture and effects, horses, carriages, motor cars, yacht, and jewellery. She had a life interest in his residuary estate, and upon her death, it was going to go to Trinity College, Cambridge. After Sir Pierce's death, his executors incurred considerable expense in retaining staff to look after his household furniture and the horses and the carriages specifically bequeathed to his wife. They also had to pay the wages and expenses of the captain of the yacht and for repairs to the yacht. Sadly, the testator's wife actually died just after a month over he did. So the executors took out a summons for determination of the question of whether the widow's estate had to bear any of the expenses for the upkeep of the horses and the yacht and so on, or it should fall on the residuary estate of the testator. The judge concluded that as specific legatees were entitled to any profits accruing from the gift, any profits from the date of the testator's death, it seemed only fair that a specific legatee should also be charged with the costs of the upkeep and the care and the preservation of the specific legacy from the time of death until the executor's assent. The decision in Re Pierce was then followed in Re Rook in 1933 and developed slightly in Re Collins's will trusts in 1971. Again, that case is on the side. The judgment in Re Collins is also quite good. It assures us early on that the testator here was recognized in philatelic circles as an experienced collector of stamps. For anyone interested, philately is the study of postage stamps and postal history. And according to the internet, philately involves more than just stamp collecting or the study of postage, and it is possible to be a philatelist without owning any stamps. Sadly, I don't have any more details on that, but the testator in this case did have a stamp collection that was valuable and extensive. He also had a coin collection and a Volvo. The will provided for certain beneficiaries to be given the opportunity to select items from his personal effects, which included, the judge held, the stamp and the coin collections and the car. The executors had spent a not insignificant amount on storing and insuring the car and insuring the valuable stamp collection. The question arose about whether the expenses should fall on the residuary estate or on the particular beneficiary who was to make the selection. The judge said that in most cases, there can be no doubt that the title of a specific legatee will stem from the will itself. But in a case like this one, where the particular beneficiary is given a power of selection, the title stems not directly from the will, but from the act of selection. The judge concluded that in that kind of case, if the subject matter of the selection had produced any profits prior to the selection, those would have belonged to the residuary estate. So accordingly, the expenses of preservation and storage and insurance incurred prior to the selection should also fall on the residuary estate and not on the person who ends up selecting that item. So really, he uses the same logic as in Re Pierce.
Great. Numismatics, I think, or numismatism is coin collection. So you can Google that afterwards, Arabella, and see whether you need to own any coins for, for those purposes.
You're useful on a pub quiz, is what I've learned.
Finally, payment of expenses and partial intestacy. So the question here really is, out of which pot are liabilities and expenses met if there is a partial intestacy because part of the gift of residue has failed? So the starting point is section 34.3 of the Administration of Estates Act, which I have quoted there, which says that a solvent estate shall, subject to the provisions, if any, contained in his will, be applicable towards funeral, testamentary and administration expenses, debts and liabilities payable in the order mentioned in part 2 of the first schedule. And if you turn to part 2 of the first schedule, part 1 having been, I think, deleted or revoked, it says at point 1, so the first sort of category of property which bears expenses, etc., is the property of the deceased which is undisposed of by will, subject to retention thereout of a fund sufficient to meet any pecuniary legacies. So, hooray, you might think. If there's a partial intestacy, then you first of all meet expenses, testamentary administration expenses, debts, liabilities, etc. from it. But do you? Because don't forget, this is, again, subject to the provisions, if any, contained in the will. So what about the following fairly standard precursor to any residuary gift? My executors shall hold my estate upon trust to pay, discharge, or provide for my debts, funeral, testamentary, and administration expenses, and subject thereto, shall hold for X, Y, and Z. Well, again, I mean, there are some slightly fine distinctions being drawn here and some divergent decisions. Back in the 1930s, you've got a case called Rees-Sanger, which didn't have actually this precise sort of wording, but rather had a residuary gift without any direction as to where debts were to be paid, and then following the residuary gift, a statement that debts, expenses, etc., should be paid from my estate. That was held not to be a contrary indication to section 34.3. But in Taylor, the deputy judge there was faced with a clause not dissimilar to the one I've included on the slide, and came to the conclusion that it was enough to displace the ordinary the rules in section 34.3 in schedule 1 part 2, and that it was an express charge, if you like, of expenses, liabilities, etc., on the residuary estate before its division. So even if following its division part of that gift had failed, that would be after all expenses had been borne, and so it itself would not be reduced by the whole of the liabilities, expenses and debts. And what's quite interesting, I mean, there are two things I think to note. One is Arabella spoke earlier about section 35 of the Administration of Estates Act, which is where charges on a property are to be borne. And there's a specific provision in section 35 which says that the sort of clause in the final bullet point there is not by itself enough to amount to a contrary intention, that the charge should be borne from the property against which it's secured. Whereas section 34 doesn't contain anything as explicit as that. And you might think, yes, that is a pointer in favour of retailer, that if you contrast section 34 and 35, section 34 doesn't say that the residuary gift in the form that I've just described is not a contrary intention. But it's a slightly different approach from that in Hives and Mackin, where the judge held that a standard form bequest really wasn't enough to show a contrary intention for the purposes of section 33. However, I think it's an outcome that actually accords with common sense and what most practitioners would probably do instinctively, which is a relief. It's actually a situation where knowing a little bit of a law could be a dangerous thing, because unless you then have the further layer of the case law interpretation of section 34 and Schedule 1 Part 2, you could be led into a misstep. So I think that's what we wanted to talk about. And I see we have a few questions, and we have possibly 2 or 3 minutes to answer them. So shall we give it a go, Arabella? Shall I start? I'm going to start in the order that they arrived. So we've got one from Azim Akram about how might an administrator of an estate deal with a scenario where a legacy is left to a charity that's under investigation by the Charity Commission, which is a really interesting question. I mean, I think in practice, what I would do is as follows. I think I would communicate with the Charity Commission to find out, what's going on, what's the status of the charity and the investigation. If you, as a result of those investigations, conclude that it's not certain to whom you should be paying this money. So, for example, if there's a war within the charity about who the proper officers are, or something along those lines, you might end up in a position where you've got to go to court and ask for directions to whom it should be paid, or whether the money should be paid into court or some other protective measure. But you might well want to be careful before you start paying money over in those situations to a charity, if there's any doubt about it, who can give you a good receipt for it. And then the second question, which again I think is for me, and then the next one's for you, Arabella. But the second question is in relation to section 33 of the Wills Act. Does the contrary intention have to appear in the will itself? Is a clear attendance note when taking instruction sufficient to exclude section 33? And the answer to that is that section 33 is very clear. The contrary intention has to appear by the will. If the testator's instructions were that the grandchildren or remote heirs you should not take by substitution, then that may give a ground for rectifying the will if the omission of an exclusion of section 33 could be said either to be a clerical error by the draftsman or a failure to understand properly the testator's instructions. So you might get it rectified, but without something on the face of the will, section 33 is not excluded. And then Arabella, I think the next one is about expenses of delivery of chattels. Can you see that one?
Yeah, no, I can. And I think there's also a question about notes of the webinar, and I'm sure Joe will send the slides around afterwards. Yeah. In terms of bank fees and paying pecuniary legacies to overseas beneficiaries, I would have thought if you applied the logic that has been employed by the court through the case law, where that legatee is going to get any profit or maybe interest on a particular legacy, it's only fair that they should also have to pay for the costs of transfer, storage, and so on, particularly if it happens to be an overseas beneficiary. So I would have thought out of each overseas legacy rather than the residuary estate. I know there is a case about I don't think it was a pecuniary legacy. I think it was a chattel that had to be shipped to a beneficiary who happened to live in Monaco, and it was definitely that beneficiary that was made to pay for it and not the residuary estate, to his disappointment.
Well, if you will live in Monaco.
Yeah.
Great. Well, thank you very much, everyone. I think that's our sort of time slot up. I hope you've found it helpful. If you have, then do tell your colleagues if they would find it helpful too, that it's available on the website. And I hope you have a good day. Goodbye.
Bye.